Good morning, everyone. Thank you for joining. Welcome to Landmark Chambers' third webinar in its series of Planning High Court Challenges 2024. This particular session will deal with substantive planning law issues, and we hope you'll find the presentations and the discussion to be helpful and informative. I'm David Elvin KC. I'll be chairing today. And I'm joined by my colleagues Dan Kolinsky KC, Tim Buley KC, Joe Thomas, Ben Fullbrook, and Ed Arash Abedian, who I will introduce as they come forward to give their papers. Just a couple of housekeeping matters to begin with. Your microphones are automatically muted, so you don't need to adjust your local settings. We very much welcome questions throughout the sessions. Please submit them via the Q&A button on your screen. If you wish to remain anonymous in submitting your questions, please don't forget to tick the send anonymously box before you submit your question, and we'll try and answer as many questions as possible at the end of the presentations and possibly even in response to the written text as we go on. The webinar will be recorded and you'll get a link to the presentation and to the recording shortly after the event is concluded. Please, if your connection is lost at any stage during the webinar, just rejoin the meeting by re-clicking the original link. Thank you very much. So to begin, the first paper this morning is a paper on possible High Court challenges arising out of the Levelling Up Act, and it's given by Ben Fullbrook. Ben was called to the bar in 2016, has specialised since then in planning and environmental law matters, with a particular focus on High Court challenges. He acts for a wide range of clients, including developers, community groups, local authorities and government, and he is on the Attorney General's B panel of counsel. Ben.
Thank you very much, David, and thanks very much for joining us this morning. As David said, I'm going to be speaking about possible High Court challenges to the Levelling Up and Regeneration Act 2023, and I'm hoping, get the slides going, there we go. Right, so this is quite clearly an exercise in crystal ball gazing on a number of levels. That's partly because many of the key elements of the Levelling Up and Regeneration Act, or the LURA, haven't been commenced yet, and we don't still know when they're going to be commenced. So there's no basis for any judicial review claims or High Court challenges yet. And of course, another problem is we can't say, we don't know what facts will arise and give rise to those changes. And that's why I've sort of put up the picture from Minority Report there, which is the film about pre-crimes and trying to solve crimes before they even happen. So there are a number of limitations in what I'm able to do and able to say about this. And all I can really do is look at some of the key changes that may be affected by the LURA if they're brought into force, and ask a series of questions about them, which the courts may need to resolve in due course. So that's the structure that I have looked to follow here. And so I've got a few brief slides. And the first topic to look at is decision making. And this is, if it comes in force, going to be one of the key changes brought in by the LURA. So first of all, the LURA is going to create the ability to make National Development Plan policies, or NDMPs. And these are going to be policies which effectively are just designated as such by the Secretary of State. And last time I checked, last week, there was a sort of ministerial announcement that the government's planning to consult on its NDMPs next year, with a view to then issuing them and a new slimmed down NPPF, which is just going to deal with plan making. So this is something that is likely to come online in the next year, but certainly not in force now. So we'll have the new NDMPs, and we'll also have effectively a new Section 38.6 duty, although confusingly it's going to be in Section 38.5 of the Planning and Compulsory Purchase Act. And that's going to change the duty ever so slightly. And as you can see, I've written it down there. So the duty will be that determining planning applications must be done in accordance with the development plan. So far, so good. And any national development plan policies taken together, unless material considerations strongly indicate otherwise. And then subsection 5C deals with the event of conflict between an NDMP and the development plan, and says that in the event of such conflict, that must be resolved in favour of the National Development Plan policy. So key changes there obviously are the role of NDMPs, and that word strongly, which has clearly been introduced to increase the weight to be given to the National Development Plan and the local development plan. But what does it mean, or what will it mean in practice? So that poses a couple of questions. First of all, yes, gone too far there. What has to be shown for material considerations to strongly indicate otherwise? Now, I had a look on Westlaw. I couldn't find any other statutory formula. I'm happy to be corrected, but a statutory formula that uses that word strongly indicate. So what does it mean, and how will it be applied? I mean, clearly, in a general sense, it just means you have to show more than you would have had to previously to overcome what's said in the development plan, or to reach a conclusion which is not in accordance with the development plan, and therefore it increases weight which is going to be given to that plan. How is it going? How should it be applied by decision makers, and what role will the court take in any of this? Well, it's possible that one analogy is the sort of tilted balance test that's currently contained in paragraph 11D of the NPPF. And just as an example, in Barwood Strategic Land and East Staffordshire Borough Council, Lord Justice Limblom said about that where a development which does have the benefit of the tilted balance, it may still be found to be unacceptable and planning permission for it refused. This is the territory of planning judgment where the court will not go except to apply the relevant principles of public law. In other words, so long as the decision maker makes it clear that they're applying the right test, in that they're asking themselves, do material considerations strongly indicate that the permission should be granted or refused or whatever, in contravention of the development plan, then the court's unlikely to do very much. It's really just a question of the local planning authority ascribing the right amount of weight to the various components of that balancing exercise. But possibly the courts might require a more structured approach, such as has developed in the heritage context, certainly through the NPPF. I mean, the courts are less prescriptive about structure, but the NPPF says, well, you look at the development plan, you look at you look at the heritage harm, and then you look at whether the public benefits outweigh that, giving great weight to the heritage harm. Is there going to be a need for a more structured approach to be brought in? My view is that, as I said, there are likely to be several legitimate ways of carrying out this balancing exercise. And again, the heritage context is a good analogy there. If you look at the city and country case, where how one goes about the exercise is really a matter for the decision maker, and there's generally been a repudiation of a sort of excessively formulaic approach to planning law. But I've no doubt that there will be litigation about what this means in practice and how it works, and it obviously remains to be seen how it will be developed. But one suspects that quite a lot of latitude will be given to decision makers, and it really is just a question of weight. It's just about making sure that the right amount of weight is given, particularly to the development plan. But there are other questions as well it raises. So let's just flick through to the next slide. Hopefully, there we go. What happens where there is conflict between the development plan and the NDMP? Now, and what does it mean for the development plan and the NDMP to be taken together? Now, as we've seen, subsection 5C says if there's conflict, you must defer to the NDMP. But then where does that leave the development plan in that situation? Does it then just become another material consideration? Does it become completely irrelevant? Is it in fact more than a material consideration? Does that strong presumption in favour of it still apply, even though it's outweighed by the NDMP? Now, these might be questions with easy answers, but I'm not sure. I think they're legitimate questions to be asked. And what about a situation where material considerations strongly indicate that the development plan should be preferred to the NDMP? Say they conflict on a particular matter, maybe about affordable housing or something like that. If you decide to go with the development plan, where does that leave the duty to resolve conflict between the development plan and the NDMP in favour of the NDMP? So there are quite a few complexities here that I don't think the courts have dealt with in other contexts, and it will be interesting to see how those two documents work together. Over time, there's obviously going to be significant conformity between the two, but there will obviously be a period of time when one has legacy, quite a long period of time, I expect, where one has legacy local development plans dealing with the new national development management policies and resolving those conflicts. Obviously, whilst the NDMP is going to be preferred, I suspect that there's a possibility that decision makers may get tied in a few knots about resolving those conflicts, which could lead to some High Court challenges. So that's decision making. This is much now moving on to AONBs, or national landscapes, as they're now called in policy. This is a little bit more concrete because the LURA change has in fact been commenced, and it's been effective from the 26th of December of last year. And that changed the duty in Section 85 of the Countryside and Rights of Way Act, which relating to AONBs. It changed it from a duty to have regard to the purpose of conserving and enhancing the natural beauty of an AONB when making decisions, to a duty to seek to further the purpose of conserving and enhancing the natural beauty of the AONB. There are other changes as well, but this is the one I've focused on because it's the one that plays into planning decisions, so decision making involving AONBs in particular. Now, we can sort of work out a bit about why this change, it should be fairly obvious from the wording, but why this change was introduced by some of the things that were said during the passage of the LURA. So it was an amendment imposed by the House of Lords. The explanatory note says that this clause strengthens the duty on certain public authorities when carrying out functions in relation to AONBs to seek to further the statutory purposes, and confers a power to make provision as to how they should do this. So the idea behind it was to strengthen the duty in Section 85. So that was the aim. But what does it mean in practice? Again, this formula, seek to further, as far as I can see, is not one that you can find in other statutes or legislative provisions. So what does a decision maker have to do in its decision making to seek to further that purpose? And what does it do with development that doesn't further that purpose? What does that mean? I mean, seek to further doesn't seem to mandate a particular outcome, but it does seem to mandate an intention. So this is, I think, right for quite a lot of judicial review, High Court challenge work. Some guidance has been given. Well, it may not have the force of guidance, but Natural England has expressed at least a provisional view in consultation response that it's provided to a DCO examination. Now, that is obviously not formal guidance at all, and I believe formal guidance is being worked on. I think there may even be statutory guidance being worked on, but it hasn't yet been published. But this is all we have from Natural England on this so far. And it says that the duty to seek to further is an active duty, not a passive one. A relevant authority must be able to demonstrate with reasoned evidence what measures can be taken to further the statutory purpose. The proposed measures should explore what is possible in addition to avoiding and mitigating the effects of development. It's not still entirely clear how that's going to apply to particularly individual planning decisions. And in fact, we are likely to see some guidance from the High Court on this in due course, because I'm aware of a couple of challenges which relate to the application of Section 85, sorry. So the first is New Forest National Park Authority, which is a claim which says, among other things, that the Section 85 duty wasn't applied properly. And that's going to be heard in December, so next month. And then there's the Dedham Vale Society. That's a case which I'm representing the claimants in. That is a case about, it's slightly complicated, but it's about some development to a railway car park, which would be permitted development were it not EIA development. And the local authority initially decided it was EIA development, and then after a screening direction from the Secretary of State, the Secretary of State deemed it not to be EIA development. And there's a question there about whether the Secretary of State should have considered Section 85 when carrying out the screening direction, and what role Section 85 had in that screening direction process, and whether it makes any difference to the process that the Secretary of State undertakes. And that's a case which definitely raises questions about what Section 85 means, as well as how it might operate in practice. And that's going to be heard in February of next year. So by the time we give this presentation next year, we'll have some answers at least in relation to that. But clearly, Section 85 has changed. It has become stronger. It is something that decision makers, local authorities, Secretary of State will have to think carefully about in their decision making from now, or albeit we await more guidance about how it's supposed to be applied. So that's AONB. And then heritage. Not much is changing with heritage, but it is absolutely ripe for High Court challenges, and so many do raise heritage issues. So I thought I'd mention anyway. Section 102 of the LURA, which again hasn't been commenced, amends the List of Buildings Act, extends statutory protection to scheduled ancient monuments, registered parks or gardens, protected wreck sites and World Heritage Sites. So these are already protected in the NPPF, but it extends the statutory protection to those. It also slightly amends the duty in Section 66 of the Act to extend it to a duty to have special regard to the desirability of preserving or enhancing the listed building or its setting. So it's adding the word enhancing there. I think that's very unlikely to cause any significant difficulty or problems. So first of all, it's an alternative. So the focus previously been on preservation, and that will obviously continue to be the case, but enhancing is also something that special regard has to be had for. But this really, all it does is it brings us into line with what's already said about conservation areas in Section 72 and with what's already said in the NPPF. So it's unlikely to cause too many difficulties, but it's worth being aware of because, as I said, heritage is one, an issue that arises commonly, and two, one which often gives rise to High Court challenges. Okay, and then moving on to material amendments. I put that in quotation marks because I think most people know, and I'm certainly some of my colleagues will correct me, that they are not amendments to planning permissions. This is these are new planning permissions which are based on but slightly different from existing planning permissions. So we're talking about Section 73 effectively here. And what we have is Section 110 or 110 of the LURA. Again, we don't know when this is going to come in, but it's going to introduce a new Section 73B to the Town and Country Planning Act. Now, the reason why this was introduced was to address the effect of Finney and the Welsh ministers, which effectively found that Section 73 can't be used where the effect of doing so would change the description of development or insert a condition which was inconsistent with the description of development. And this has led generally to developers having to take sort of steps to work around the effects of this by generally using non-material amendments to change the description of development in planning permissions, and then using Section 73 to change the conditions of that planning permission. What Section 73B will enable you to do is to change other elements of the planning permission. So you'll be able to change the description of development as well. That's the aim behind it. And how it works is, or what it sort of gives the right to do, it gives developers the right to ask local planning authorities to determine applications to vary a planning permission if the effect of the resulting permission is not substantially different from an existing permission. So that's the gateway effectively to Section 73, not substantially different from an existing permission. So you need a permission, and you need another permission that's not substantially different from it to engage it. And then when it's engaged, what do local authorities have to consider? It says local authorities must limit consideration to those respects in which, if granted, the new permission would differ in effect from the existing permission. So that clearly, now Section 73 has been a very, very tricky area. It continues to be a tricky area with various significant High Court decisions in the last couple of years on what it means and how it should be applied. This is not, I think, going to change with Section 73B. It raises a number of questions. The first is, what does not substantially different mean? We really don't know. And is it different from what you can do under Section 73 as regards conditions? So we do know from some of the recent authorities that there's this concept of fundamental alteration in Section 73. So if you look at FISC, that said that Section 73, or certainly it purported to confirm that a Section 73 application couldn't be used to make a fundamental alteration to an existing planning permission. Although if you look at Armstrong, it went even further, saying that even that wasn't a legitimate limitation. All the only limitation was the Finney question, where you can't conflict with the description of development. So there's quite a broad latitude to make changes in Section 73. Where does this not substantially different test fall within that? Is it the same as a fundamental alteration, or is it something less? Certainly, wording to that effect was included in previous iterations of planning practice guidance, which have largely been debunked because they referred to Section 73 involving the power to make minor material amendments to the PPG. But several cases, including the Armstrong case in particular, have said there's no basis for that formulation, minor material amendment. There's no restriction. Section 73 is not restricted to minor material amendments to planning permission. So if not substantially different means minor material amendment, then potentially the scope for changes under Section 73B is less than the scope for changes under Section 73.
Sorry to interrupt. You've got 1 minute to go.
Oh, thank you, David. That's absolutely fine. Thank you. That's very, very kind of you. So what does it? So clearly, in summary, there's going to be litigation about this, and it's not clear. It will be very difficult to use. And also, there's this question about what about development plan changes? What about development changes? So development plan changes. So if your consideration must be limited to those elements of the permission which differ in effect, what about if the effect is broadly the same, but the development plan changes? Can you consider that? I mean, I think the authorities would suggest you have to consider that. Certainly in the context of Section 73, you do. But that formula is likely to lead to some questions being asked as well. Oh, and then finally on enforcement, I don't have a huge amount of time. You'll get the slides there, but there's been a tightening up of the ability to bring ground A challenges against enforcement notices, where there has previously been a planning application which is related to the enforcement notice. And where that's the case, you can't bring a ground A appeal within 2 years of the date on which the planning application was finally determined. And there are questions then about what does related to mean. That has actually been considered previously by the High Court, but I think it's something that, given there's been a tightening up, is something that might arise again. And so those are all the main questions that I have, certainly about the LURA, but there'll be many more, I'm sure. And with that, I shall hand over to David. Thank you.
Thanks, Ben. Ed will now give you a paper, on the latest case law under the NPPF. Ed practices across all the ranges of planning, environmental and public law, has acted in a number of planning matters, including as sole counsel on behalf of planning authorities and Rule 6 parties, and his current instructions include an ongoing challenge to a DCO application for an energy project in Eastern England representing local residents. Ed, thank you. Sorry.
Thank you very much, David. Morning, everyone.
Sorry.
Morning, everyone. So I'm providing a case law update, and I've grouped these under 4 key themes. So the themes are, as you can see there on screen, the first, we'll look at the weight given to economic benefits of a proposed development. Then we've got a case dealing with biodiversity net gain and the weight to be given to that as a benefit. We've also got a case relating to the relationship between planning practice guidance and the NPPF. And then finally, a case on the Section 38.6 balancing exercise under the 1990 Act. So the first case I wanted to cover is the case of Buley Homes. So this is a decision of May 2024 from Mr. Justice Holgate, now Lord Justice Holgate. I believe actually all of the cases I'm going to look at today are decisions of Lord Justice Holgate. So this was a Section 288 challenge, and Buley sought outline planning permission for up to 140 dwellings in Farnham. The claim was concerned with policies in the 2021 version of the NPPF, those dealing with economic growth and productivity. The policy wording, however, is the same in the latest version. So in particular, we're dealing with what then was paragraph 81, which is now paragraph 85. So that's under chapter 6, entitled Building a Strong Competitive Economy. And the paragraph itself states that significant weight should be placed on the need to support economic growth and productivity, taking into account both local business needs and wider opportunities for development. Now, the claimant here advanced two grounds in relation to this paragraph. The first is that the inspector misinterpreted paragraph 81, now paragraph 85, in two respects. Firstly, in stating that the principal focus of the policy was on business investment, expansion, and adaptation. Instead, what was being argued was that that paragraph was dealing with all economic benefits of any proposed development, and that included residential development. And the second limb, or the second ground, was around the weight given to economic benefits. So here the inspector only gave moderate weight. What was being argued was that significant weight had to be given to the economic benefits of any development. So in essence, the claimant was arguing that the policy was a blanket assignment of the degree of weight to economic benefits in any case. So a type of uniform prescription or of significant weight had to be applied. What Mr. Justice Holgate said was that paragraph 81 contained a series of high-level objectives for both planning policies and decisions. So when read as a whole, the emphasis of that paragraph was on the encouragement of different forms of economic development. The significant weight being referred to was being placed on an objective, i.e., the need to support economic growth and productivity. And that was the same as what's in paragraph 8 of the NPPF, specifically in relation to the economic objective in the bullet point. The judge also said that the nature and extent of the support to economic growth will vary from one area to another, and those matters will be reflected in the formulation of policies in local and neighbourhood plans. Paragraph 48, what Mr. Justice Holgate said was that it's clear that Chapter 6 of the NPPF and paragraph 81 here in particular, they don't suggest, whether expressly or by implication, that significant weight should be given to any economic benefit flowing from any development proposal. And what the judge says was that if the Secretary of State had intended that to be the case, to lay down a general policy of that kind, well, it would have been easy for the Secretary of State to say so, and they would have said so. They didn't, though, and the language of the NPPF didn't allow the court to imply any such policy in this case. So what that means is that the economic benefits of a proposal will vary widely dependent on their local or wider context. So here the benefits being relied on by the developer were of a general and unquantified nature and typical of the benefits which could be claimed for most residential development throughout the country. Sorry, I'm just having a few issues with my slides. There we go. And I've just set out two particular paragraphs, which I believe are, there we go, two particular paragraphs which set out Mr. Justice Holgate reasoning on this. The first is paragraph 53, which states that the NPPF does not compel decision makers to do something absurd, namely to attribute the same level of weight, i.e. significant, to economic benefits from any proposed development, irrespective of the merits of the economic case, or even whether the developer provides no information on the level of those benefits. And the point in paragraph 59, in essence, is that the decision maker is not required to assign a uniform level of weight, and that they can assign such weight as they consider appropriate, having regard to the nature and extent of those benefits in light of all planning considerations relevant to that assessment. So in essence, what's the analysis? Paragraph 85, which is what it's currently, that's not a blanket policy which can be relied on to ascribe significant weight to any and all economic benefits arising in any proposal. The level of the benefit to which it is applied will be bigger or smaller according to the circumstances of the case, and so the ultimate weighting will vary in the overall planning balance. And then as a practical point, applicants will need to properly specify and quantify the benefits which arise specifically as a result of their proposal. You'll notice the number of times Mr. Justice Holgate referred to the unqualified, unquantified, and general nature of the benefits being relied on. And they'll also need to demonstrate how these benefits apply specifically to the particular local context. Moving on to biodiversity net gain. This is the case of Vistry Homes. And there were actually two different claimants in this case. So we've got Vistry Homes and also Fairfax Acquisitions. Again, a decision of Justice Holgate made in August of 2024. Both were 288 claims. Both decisions by inspectors on planning appeals relating to large residential schemes in the Greenbelt. And in each, it was common ground that the development constituted inappropriate development for the purposes of Greenbelt policy. So accordingly, each development was, by definition, harmful to the Greenbelt and could not be approved unless the very special circumstances test was passed. Now, what that means is that the harm to the Greenbelt by reason of inappropriateness and any other harm resulting from the proposal had to be clearly outweighed by other material considerations. That's the test in paragraph 153 of national policy. And between both cases, the BNG biodiversity net gain issue was common in both, the complaint being that the relative weight given by the inspector to those benefits was incorrect, and the analysis revealed an error of law. So in Vistry, moderate weight was given to BNG, and in Fairfax, it was limited weight. There's important legislative background here. So the Environment Act of 2021, that introduced a requirement for a condition to be included in the grant of certain planning permissions for the provision of BNG. And that requirement to provide 10% BNG secured by condition was brought into force on the 12th of February of this year. So it did not apply to a planning permission granted in relation to an application which was made before February. Justice Holgate referred to the decision in Saradin Aggregates, in which Justice Eyre held that where a developer had proposed BNG in excess of 10%, but that new statutory requirement was not yet applicable, then the decision maker could not or was not entitled to reduce the weight that would otherwise be given to that first 10% of the BNG simply because of the impending legislative requirement to provide that 10%. At paragraph 147, Justice Holgate stated that he agreed with that essential reasoning. The judge then went on to set out some non-exhaustive guidance to assist decision makers dealing with this particular issue. So paragraph 150 said that while it's sometimes suggested that where a development makes provision for something which is required by policy or legislation, that cannot be regarded as a benefit at all. So, for example, in Fairfax, the decision had stated that measures that do no more than ensure compliance with development plan policies cannot be benefits. Well, what Justice Holgate said was that there's no legal principle which supports a statement of that kind. Then went on to say that the assessment of how much weight to give a benefit is a matter of judgment, subject to the application of public law principles, and that includes avoiding irrationality. So where a development is required to provide a measure in order to overcome or to mitigate or to compensate for a harm caused by a project, ordinarily that measure can't be rationally described as a benefit. So an example given is where a development would result in a loss of biodiversity. the provision of additional biodiversity on the same site or another land nearby in order to completely offset that loss, well, that's not a benefit. It's simply the development consuming its own smoke. But you can contrast that with BNG, because as the name and definition indicates, that's referring to an improvement in biodiversity. So you're going beyond offsetting the adverse impacts, and you're increasing biodiversity in order to help redress a general national problem, which isn't necessarily caused by the development being proposed. What the judge held here was that on any view, would be a benefit of the proposed scheme. So it's difficult to see rationally how anyone could argue otherwise. What I'd note here is that this part of the analysis is looking at whether or not it's a benefit. So the weight to be attached to that benefit, well, that's a separate consideration, and we'll come on to that in a second. So what we take from this is at paragraph 154, which is that the identification of what is and what is not a benefit should not be altered because what would otherwise be recognized as an improvement or benefit is subject to a requirement imposed by policy or legislation. And it also follows that where a development would provide, for example, 20% BNG, a decision maker can't say that only that part of the BNG which exceeds 10%, so exceeds the requirement, the national requirement, can qualify as a benefit. Paragraph 163, the judge also said that where the application for permission is made before February of 2024, the statutory 10% requirement should not be treated as having been applicable, and nor should that be the effect of the decision maker's reasoning. Interestingly, however, the 10% BNG provision in Schedule 7A of the 1990 Act, that may be used, but only as a benchmark in assessing the weight to be given to a BNG contribution. So it can't be used to reduce the weight that the decision maker would otherwise give to the provision of BNG in a particular case. Now, in both these cases, both in Vistry and in Fairfax, the judge found that the inspectors firstly had acknowledged that BNG was a benefit, and having done that, they were then entitled to use 10% as a benchmark, rather than implying that BNG of 10% or below was not a benefit in and of itself, or that the weight should be discounted because of the future legislative requirements. So on that basis, the judge found that the inspector's reasoning was sound, and the claims were therefore dismissed. So what's the takeaway here? BNG, regardless of the legislative requirement, is to be treated as a benefit. Following that, the weight is a matter of planning judgment. You can't reduce the weight which would otherwise be given simply because there's a legislative requirement in place. But what you can do is you can look at the extent to which the BNG provision exceeds that statutory requirement and assign weight accordingly, using that 10% as a benchmark. So moving on to the third case. Which is the case of Mead realizations. So this is a decision from February of this year, again, Justice Holgate. And here we had two Section 288 claims, which raise issues about the interpretation and application of the sequential test in national policy on flood risk. Now, in each case, the inspector refused permission on the basis that the sequential test was not met because there were reasonably available sites for residential development appropriate for the proposal, with a lower flood risk than on the appeal site, and the presumption in favour of sustainable development was disapplied. Now, in each case, the applicant for permission applied for statutory review, contending that the PPG was not national policy, but merely guidance, and as such, the definition of reasonably available or a reasonably available site in paragraph 28 of the PPG was incapable of imposing a binding and more stringent set of requirements than those within paragraph 162, which is now paragraph 168 of the NPPF. Now, what Mr. Justice Holgate said here was that it's not accurate or helpful to say that the PPG is only guidance, as if to suggest that it has a different legal as opposed to policy status from the NPPF, or that the fundamental principles on policy do not apply to both of them. Neither has force in statute, neither has binding legal effect, and the ability of the Secretary of State to adopt either derives from the same legal source of power. Justice Holgate then gave examples of where the NPPF and the PPG interact. So some of the examples he gave were, for example, paragraph 57 of the NPPF, which lays down the 6 policy tests for imposing planning obligations, which derive from the Newbury criteria. Here he said that the PPG explains the application of those tests, and there's no reason why the PPG should not be treated as a statement of planning policy. The same he said in respect of paragraphs 201 and 202 of the NPPF, which relate to deciding whether development would cause substantial or less than substantial harm. Again, the PPG here is a planning policy which sets out more, which provides more specific guidance, because, for example, substantial is not defined in the NPPF, and neither is public benefits. What the judge said was that the policies in the NPPF vary in style. Some, for example, greenbelt policies, they're relatively detailed and prescriptive. Others, or other parts of the NPPF, set a framework, and the PPG provides more specific or detailed policy guidance. And with that in mind, guidance for decision-making should or should not be treated as policy according to whether it's been subject to prior consultation. That's not an appropriate test, is what Mr. Justice Holgate said, as had been advanced by the claimants in this case. It's paragraph 70, we get to one of the crux of the point here. As a matter of policy, PPG is intended to support the NPPF. Ordinarily, therefore, it's to be expected that the interpretation and application of the PPG will be compatible with the NPPF. However, there's no legal justification for the suggestion that the Secretary of State cannot adopt PPG which amends or is inconsistent with the NPPF. And that was essentially the argument being advanced by the claimants in this case. What Mr. Justice Holgate also said was that he was unimpressed by the argument that the PPG cannot be adopted, which is, in quotation marks, restrictive of NPPF policy. So where policy in the NPPF is in very broad or open terms, you may get guidance in the PPG, which may be more focused as to the approach to be taken. So Justice Holgate said that here, terms such as restrictive are somewhat inappropriate and unhelpful because they tend to be quite one-sided. Additions to or changes in policy may produce winners and losers, and that's perfectly acceptable and to be expected. So concluding, what Mr. Justice Holgate essentially said is that the interpretation of paragraph 162 or 168 of the NPPF, read together with this particular paragraph in the PPG, paragraph 28, that was an objective question of law for the court, not judgment for the decision maker. And although the process of interpretation does not need to allow for exceptionality or a discretion, that should not involve treating either policy as binding. Once the court has reached its conclusions on the interpretation, the application of the policies were a matter of judgment. So in essence, you've got that fundamental distinction between interpretation, which is for the courts, and the application of policy, which is for the decision maker. And in the case before him, Holgate found that there was no legal error in the inspector's conclusions because the PPG was consistent with the open texture language of the NPPF, properly understood here. The former was merely clarifying the latter, and so the inspector correctly treated the PPG as having elucidated the NPPF. And my final case is on the section 38.6 exercise.
And Ed, you've got about a minute to go.
Thank you, David. If only my slides would move. I'm not sure why it's not. There we go. Okay. So Basingstoke case, I'll try and cover this quickly. Again, Holgate, Mr. Justice Holgate decision, looking at section 38.6. So as most of you will know, section 38.6 has two limbs. The claimant here, the Borough Council, submitted that the issue of whether all or some of the policies of a development plan are out of date is legally irrelevant to the first limb of Section 38(6). That could only be taken account under the second limb. What Mr. Justice Holgate said here was that Section 38(6) does not lay down how much weight should be given to the development plan, and he referred to the judgment in Loop, which was approved in the City of Edinburgh case by the Supreme Court. He also referred to the case of Gladman, where the Court of Appeal considered the relationship between statutory presumption in favour of the development plan, so that's 38(6), and the policy presumption in favour of sustainable development, that's paragraph 11 of the NPPF. And the court rejected the appellant's contentions in that case that development plan policies were only to be taken into account in the balance under Section 38(6) and not paragraph 11, and that the two presumptions had to be applied separately. In essence, the court held that these two provisions could be applied either separately or together in a single comprehensive exercise. And what Mr. Justice Holgate said was that here, this applied with even greater force because we had a specific policy in the local plan, SD1, which created a policy presumption in favour of sustainable development, and that, in essence, reflected paragraph 11 of the NPPF. Now, you might wonder whether that analysis would have been any different had that specific policy not existed in this particular case. Well, Mr. Justice Holgate addressed this specifically at paragraph 98. And what he said was that I don't consider that the dismissal of this claim depends on the fact that the local plan includes policy SD1, even if that policy is disregarded for the sake of argument, there's no error of law, the inspector would still have been entitled to take into account the out-of-datedness of the spatial strategy of the plan when deciding whether the proposal was in accordance with the plan as a whole. He then referred to the case of Mill, which decided that whether a proposal accords with a development plan is not a linguistic exercise, you're going to have policies which pull in different directions. And what the decision maker's task is to form a view on the relative importance of the policies and the nature and extent of compliance with those policies. And as part of that, it's relevant to consider how the proposal relates to the objects or purposes of the relevant policies or the plan.
Yeah.
And here,
Ed, can you wind up now, please?
Yeah. So here, the inspector had found that housing delivery had failed. That was crucial. So the inspector said that spatial strategy was not delivering the required housing that the plan was intended to deliver. And it's because he considered that the spatial strategy was not delivering its intended purpose. That's why he concluded that the plan was out of date and needed to be reviewed. So that was important here. And in these circumstances, that approach couldn't be criticized. That's it on that case. I just know there were two particular cases that happened this year that I haven't referred to. My colleagues throughout the course of this year have done specific webinars on these, so I just urge you to have a look at them, and they're just noted there. Thank you.
Yes. Thanks, Ed. Yes, particularly note that the Fry case has been given permission to go to the Supreme Court on the issue of subsidiary consents and habitats assessment. I now want to introduce Tim Buley KC, who is going to deal with PSED challenges in planning. Tim is well known. He specialises in planning, public law and regulatory law, focusing particularly on High Court and Court of Appeal challenges in the admin and planning courts, and is recommended as a leading silk, he tells me, in 6 areas in Chambers and Partners. Well done, Tim, including administrative law and planning, and has got vast experience in bringing and defending judicial review in planning and environmental matters. Tim.
Hello, thanks, David. Hi, everybody. Right, so I'm going to talk about the public sector equality duty in the context of planning cases. Oh, how are these slides working? There we go. So I was thinking about this as Ben was speaking, because there's some sort of familiar language in section 149 of the Equality Act, have regard and so forth. It's a duty it's a kind of duty we're used to in planning, perhaps more used to in planning than in other areas, where you have to have regard to certain matters. The statute specifically tells you to have regard to certain matters in making decisions. But of course, the public sector equality duty, unlike the duties that Ben was talking about and other similar ones, is not specific to planning, and it's often been more important outside of the planning sphere, where it's often referred to, than in planning specifically. But it does have a bearing, it does certainly potentially have a bearing, so we need to look at it and see how it works. So the duty itself set out in section 149 of the Equality Act 2010, and section 1491 provides that a public authority must, in the exercise of its functions, have, and I've emphasised because everybody does when they talk about this, the words due regard to the need to, and then there are various things you have to have regard to. I'll come back to that. So first of all, as I say, it's regard. That's a classic formulation used in a statute of something the decision maker is told by the Parliament they have to think about, but they're not told what conclusions to draw from it. So we'll see again how this is put in the cases in a minute, but it's a procedural or a public law duty, a duty to think about things, not a substantive duty, and that's worth emphasising especially here, because it's found in the Equality Act where there are substantive equality duties, duty not to discriminate, where the court itself can decide whether the person being challenged, who may or may not be a public authority, has got it right. The public sector equality duty is specific to public authorities, and it's a duty only to think about various things. Then there's that curious wording which is always picked up by the courts whenever they talk about this case. Due regard. What does due regard mean? That's that word I don't think does appear in any of the similar duties. That, for example, those that Ben was talking about earlier, of having regard to certain matters, A, O, and B, and so forth. No one knows what it means really. It means have regard to give regard that is due in all the circumstances, the courts tell us. What that I suppose does mean, and it's a point I'll come back to, and the point the courts have said time and time again, is that context is everything when it comes to the PSED. The real importance of it, it just varies enormously. There are times when there's really not much of relevance coming out of the PSED to think about, but where appropriate, the courts may say, well, you really more regard than has been the decision maker thought they needed to be had, and therefore the decision is unlawful. And then the last point to note, and just coming back to the three elements of the subsection, the things you've got to have due regard to are, and I think this is important, the need to do certain things. So it's not just have regard to these matters, you've got to have regard to the statute is telling you that they are matters that you are required to treat as important, albeit how important will vary according to context. And then their positive duties to eliminate discrimination, to advance equality of opportunity and foster good relations. So it's not just not discriminating, the authority itself mustn't discriminate, it's got to have the need to, the desirability of advancing those aims. And then the rest of the section we'll just spend a bit more time on. Subsections 3 to 6 tell you a little bit more about what those different things mean. I'm not going to look at all of these, but I note subsection 3, having due regard to the need to advance equality of opportunity. Remember, that's the second of the aims, B1B. Having due regard to the need to advance equality of opportunity between persons who share protected characteristics, etc. Involves having due regard to the need to do various things. So removing or minimizing disadvantages suffered by persons with that characteristic, meeting their needs, and encouraging persons to participate in public life. And then subsection 4, taking that further on, the steps involved in meeting the needs of disabled persons, where that's going to be particularly important, include taking account of their particular disabilities. And then lastly, we'll take it very quickly as to the subsection 7 tells you what the relevant protected characteristics are, and I won't read them all out, but I've underlined 2 which are perhaps slightly more relevant, slightly more likely to be relevant in planning cases than others. Disability, because of the effect that the built environment can have on disabled persons, and race, particularly in the context of travel and gypsy cases, perhaps alone. So before we look at the planning cases, I just want to touch on one slightly more general authority, which is bracking, because bracking is the case. I mean, there are thousands of authorities on the PSED over the last, I say thousands, there are almost certainly hundreds, not perhaps thousands of cases. and they all say slightly different things, and it's very difficult sometimes to draw them together or bring out any principles from them. The closest thing we've got to a lead authority, perhaps, and even this is not wholly satisfactory, is the Bracking case. It wasn't a planning case, but Lord Justice McComb gives a much quoted list of principles. Some of them, frankly, are more helpful than others, but I've just picked out a few which I think are worth being aware of and which I think sometimes get lost sight of. So point 3, and he returns to this is why it's not the most helpful case because of the degree of repetition. But anyway, the relevant duty is upon the minister or other decision maker personally. What matters is what he or she took into account and what he or she knew. Now, the reference there is to the minister. And of course, in planning, we're often dealing with local authorities or inspectors. But for the words of the minister, you can substitute the decision maker. The reason why that matters, and I think this is sometimes lost sight of, is that it is the person making the decision, the planning inspector or the local authority delegated person or whoever it is, who has to have regard to these matters. And what you do sometimes see in the public sector equality sort of methodology is that an authority or a public body will produce a almost separate decision, an equality impact assessment, which sets out what the equality implications are without really drawing any perhaps conclusions. They're often actually quite bland. Now that's fine, that's a perfectly legitimate technique if it's factored into the decision making, but the decision maker does then need to look at that document if that's what's done. And you see the same point coming out in the other points here. So these and other points were reviewed by Lord Justice Aikins in Brown. And then I think the other point I just want to pull out of this is point 1. The public authority decision maker must be aware of the duty to have regard to the relevant matters. Now, as we'll see in the cases, the decision maker doesn't actually have to refer to the section or indeed refer to the duty, that's clear. But the court must be satisfied that they're aware of the duty itself. And the reason for that is it's not just a duty to have regard to eliminating discrimination, etc. It's a duty to have regard to the need to do those things. In other words, the section is dictating not how much weight is to be attached to these matters, but at least that they are to be treated as matters of importance or desirability. And then there's a list of other matters which I won't read out. There are varying assistance and specificity, but it repeats the point that the duty is non-delegable. And then 2 other points from Bracking. The absolutely central point that all of the authorities make, I've given you a passage from Lord Justice McComb quoting from an earlier case. I won't read it all out, but the court is not the decision maker. Back to that point, it's a procedural duty. Decision maker doesn't actually, the court doesn't have to decide what the equality implications are for itself. It needs simply to be satisfied that the decision maker has had appropriate regard to the duty. And then there's a duty of inquiry. The public authority concerned will need to take steps to make sure it informs itself appropriately. It can't just sit back and say, well, there's nothing obvious, no obvious problem here, end of story. It has to, in an appropriate case, again, all will vary according to facts, it may need to take its steps to inform itself of the relevant matters. Turning then to some planning cases, Coleman is, I think it was Lindblom, Mr. Justice Lindblom at the time, actually. By the way, this is, and it may be a feature of the vintage of the cases, unlike some of the earlier talks, I won't be referring to any cases decided by Mr. Justice Holgate, but we've got a few from Mr. Justice Lindblom, as he then was instead. So again, you see similar themes: distinction between a duty to achieve a result and a duty to have regard. It's a duty to have regard. The court is not concerned with the substance. A due regard means regard that is appropriate in all circumstances. Not sure what that tells you. Those circumstances include the importance of the areas of life of the members of the disadvantaged group that are affected by the inequality of opportunity and the extent of the inequality, and such countervailing factors as are relevant to the function which the decision maker is performing. Obviously, countervailing factors in a planning context include economic and practical factors, and then all of the normal matters that are relevant to planning decision making. Nothing's excluded. The duty is not given any preponderant weight against those ordinary planning features. And performance of the duty must be an integral part of the formation of the decision. That's related to the point I was making earlier about the decision making themselves needing to consider the relevant matters for themselves. And then that's all pulled together by Mr. Justice Lindblom in paragraph 71. I won't read all that out, but it reflects many of the things we've been talking about. There's a hint though there, and I'll just come back to this briefly at the end. He says in the paragraph, second sentence from the end, this is not to say that the public sector, having picked out certain features of planning in particular, he says not to say that public sector equality duty is less onerous in a planning case than it is in others. And so he says that, but as I say, there is a bit of a hint in this case, and perhaps in some of the other cases, that the PSED will be a bit less important in, or a bit less significant, maybe significant is a better word than important in the planning context. I'll return to that briefly at the end of the talk. So let's just look at some examples from the case law. Maybe they're quite informative just to consider the general circumstances. So Baker, by the way, is it's a pre-2010 Act case, but the PSED has a predecessor in the Race Relations Act and also similar things in disability discrimination legislation and so forth. So was it, that case was about whether to grant planning permission to travellers to pitch caravans on sites in the Greenbelt, and the Court of Appeal effectively said, no, they had regard. It's one of the early cases on the need to have regard. But travellers are a classic example of where the PSED may be more important. Coleman, local authority decision on permission for a school on land which a garden centre had been situated in, which was regularly used by the disabled and elderly. That's the case we've just seen from Mr. Justice Lindblom. He held that the authority had lawfully had regard to the relevant matters. The next one, though, Lakenheath, is I think, quite an interesting example of where the PSED probably becomes a bit technical, and I think the court was right to reject this challenge. So it was planning permission for a school next to an active RAF airfield, and the argument by the objector to the school was that if you grant planning permission, that will disadvantage the children for whom the school is being built. Now, there's something slightly paradoxical about that, isn't there? Because actually the school was to be built presumably for the benefit of the children in question, and yet the objectors who were opposed to it made the point that it was to their disadvantage to grant planning permission for the school. And so in that context, perhaps unsurprisingly, the local authority, the High Court rejected the challenge. I think that's a classic example of the kind of case where the PSED is really not adding anything, because realistically, the effect of noise on children in a school are always going to be part and parcel of the planning process, and therefore of any development you're going to consider noise, and so dressing that up as a PSED challenge was slightly artificial. Compare that with the LDRA case, appeal decision for permission for an office and warehouse building to replace a car park which was regularly used by disabled people to access the riverside. And there was evidence that it would make it difficult or impossible for disabled people to access the riverside. And the relevant decisions didn't mention the PSED at all. And the court did quash that. Now that's perhaps one of those relatively rare cases where you can see that the PSED does in fact add something of substance. True it is, of course, that the implications for people accessing the river will ordinarily be part of the planning process, but the fact that it had a particular impact on disabled people in particular who would suffer a disadvantage which wouldn't be readily visible to decision makers made the difference in that case. Last case, another example of where the PSED challenge succeeded, perhaps more surprisingly, grant of planning permission for it should say a public house, not for a public house to be converted into residential development, and that was quashed for a failure to consider the equality implications on the community. Maybe quite a surprising decision, seems to me, instinctively. Maybe that's based on a slightly superficial look at the case, because again, those are the sorts of things which are bound to go into any planning decision making, and it's not clear what the PSED really adds, but there it is. Okay, final thoughts then. So compared with the ubiquity of PSED challenges in a wider public law field, the scope for reliance and the actual reliance on the PSED in the planning context is relatively rare, and success is frankly even rarer. There are very few cases that succeed. Why is that? Well, partly, I suppose, as the merits jurisdiction of planning inspectors, decisions of local authorities are looked at again on planning appeals. Obviously not true if there was no appeal and planning permission is granted, but that may be a factor. But I think the key point is that the considerations to which the PSED requires regard to be had will at times be integral, part and parcel of the planning decision making for other reasons. And I've given as one particular example of that the school noise airfield case a moment ago. There's an echo here of what the courts have said about Article 8 and planning. The planning balance is very similar to what Article 8 requires. Well, to some extent, it's a different point, but there's a similarity here where the relevant factors are likely to be considered in the round in the planning decision making, which doesn't factor in or out any particular matter. Very relevant in travel and gypsy cases, of course, but that aside, not a context in which PSED is the protected characteristics play a major role. Perhaps the disability sphere is the most relevant. Thank you very much, David. I think I've kept my time. Thank you.
Tim, thank you very much. Yeah, you get the medal for being the best person so far within time. So thank you for that, and thank you for the talk. The next paper is from Joe Thomas, who's going to talk about hedgerows, trees and planning, including the Wellingborough Walks case. Joe practices in public environmental and planning law. He's advised and represented planning authorities, developers and Rule 6 parties at inquiry and in the High Court. And he claims that he's got a particular interest in the environment as the son of a Cornishman. I won't ask Joe whether you're actually a Cornishman yourself, but please continue. Thank you.
Thanks very much, David. Can you see and hear me okay?
Yes.
Now let's just check I have control. I do. Thank you very much. So I'm going to be covering 4 topics. So we're looking at hedgerows, trees and planning law, the recent Wellingborough Walks case and other related matters. And this is the order I'm going to deal with them. I'm going to be looking at the statutory framework for trees. Then I'm going to go through the Wellingborough Walks case and then go through hedgerows. And then I'm going to return and finish with trees and the NPPF. So turning to the framework for trees. Now, trees obviously impact on amenity and obviously have environmental impacts, but they also have a specific legislative framework, and that's represented in sections 197 and 198 of the Town and Country Planning Act 1990. So section 197 is a very weak duty, but it is nevertheless a positive duty to ensure whenever it is appropriate, so lots of judgment there, that in granting planning permission for any development, adequate provision is made by the imposition of conditions for the preservation or planting of trees. So it applies both to adding trees and preserving them where appropriate. So it's a very weak duty, lots of judgment involved, but it is something you need to consider. Then we turn to section 198, which is where we find the legislative framework, the starting point for tree protection orders. If it appears to a local planning authority that it is expedient, so again, a lot of judgment there, in the interests of amenity, to make provision for the preservation of trees or woodlands in their area, they may, for the purposes, make an order with respect to such trees, groups of trees or woodlands as may be specified in the order. So that then takes us to the Town and Country Planning Tree Preservation England regulation of 2012 that require that no person will cut down, top, lop, uproot, willfully damage or willfully destroy a tree with a tree preservation order. I'm just going to pause there just to mention a limitation on my talk in that I haven't mentioned the Forestry Act, which is a separate regime. So if you are dealing with a particularly knotty issue involving trees, then it is worth also cross-checking with the Forestry Act. But for purposes of time today, we're just focusing on tree preservation orders. Now, as I'm sure you're aware, to avoid the sort of absurdity that every single tree with a tree protection order has to have its permission or can't be touched, there are then some exceptions, and they're held in Regulation 14, such as the tree being dangerous or causing a nuisance, national security, removal of dead branches, removal of danger, pruning in accordance with good horticultural practice. And that's a quotation from the regulation. But the one that I imagine we're most interested in is Regulation 14A7. So far as such work is necessary, and I'm going to underline the word necessary, to implement a planning permission. So that brings us to the Wellingborough Walks case. Now, I'm very conscious that as I discuss this, the Deputy High Court judge who decided it is following me immediately afterwards. So I've got to make sure that I cover this correctly. But also it means that if I've made any mistakes, they can be very swiftly corrected. So this case concerned a large hybrid planning permission with a roadway, Route 2, approved subject to planning approved subject to conditions, including critically a landscaping condition that mentioned, which was obviously going to encompass where the trees were going to go. Now, the developer maybe got a little bit ahead of themselves, was keen to get started with the development, and sent in some engineers or some tree surgeons to start lopping down some trees. Now, this was fiercely resisted by the locals, who believed those trees did not necessarily have to be removed. So there were obviously some trees in the way of where the road was going to go, but in terms of the supporting infrastructure, pavements, hedges and so forth, it wasn't necessarily clear that those trees had to go. So the interested party, the developer, said they were fully entitled to fell the trees since it was necessary to implement the planning permission. And the claimant and the local planning authority eventually argued that the landscaping condition needed to be discharged first. And as a side note, it's quite almost bordering on amusing reading the case of Wellingborough Walks, in which the local planning authority changes its position as it goes along and eventually reaches a position, having been a defendant, agreeing with the claimant. So it shows you the importance of getting robust legal advice at the start of these matters. So what the court decided was, relying on the case of Barney Smith and Tonbridge and Malling Borough Council, the court observed that the overall statutory scheme is one where tree preservation orders are complementary to planning control. The key task when considering how Regulation 14A7 applies is to understand what exactly is permitted by the planning permission. To the extent that what is permitted necessarily, and we come back to emphasising that word, involves the loss of trees, then that exception, that means that you're allowed to go after trees with tree protection orders, is applicable, provided it's necessary. And then it goes on to say, to the extent that what planning permission can be carried out in a way which does not necessitate the loss of trees, then the exception will not be available. So you've got to decide what the planning permission says is necessary, and then if it's not necessary, then it falls outside the exception. But what Barney Smith and Tonbridge didn't deal with is when you had this situation where you had planning permission, but also a landscaping condition. So the court then observed that the interpretation of planning permission incorporated the whole of the permission, including conditions, which is the well-known Lambeth set of cases. The court noted that the relevant conditions require, before any work on Route 2 is commenced, that a plan should be submitted to the local planning authority identifying all existing trees and what measures will be employed to protect those trees which will be retained. So I think this was essentially the critical point, is even though on any reading of the planning permission there were going to be some trees that were going to be felled, that there was that pre-commencement condition that meant you can't make any decisions about trees until it's been submitted to the local planning authority. So consequently, the court held that the exception under Regulation 14A7 did not apply until all relevant pre-commence conditions had been discharged. So in that particular case, based on those particular conditions on that particular permission, when you put it all together, they had to discharge the pre-commencement condition specifying what trees could and couldn't be demolished, lopped and felled. even though on any reasonable reading of the planning permission, some of those trees were going to have to go. Now, I conclude this discussion of Wellingborough Walks with a big health warning that this case did hinge on its particular facts and wording of conditions, so it should be studied in detail before it's used to argue any particular outcome. And it did rely on the particular wording of the condition. So that was a sort of a discussion of where the tree protection orders and the Wellingborough Walks case fit together. So we're just going to touch now on hedgerows. Now, hedgerows, although obviously have implications for planning permission, the provenance of their protection is out with the Town and Country Planning Act, and we're actually looking at Section 97 of the Environmental Act 1997, and then followed very quickly by the Regulation 5 of the Hedgerows Regulations 1997. And that finds that the removal of certain hedgerows is prohibited unless exceptions apply. Now, it doesn't apply, it doesn't apply to all hedgerows, it applies to certain hedgerows. And the test, there's three-part test on which hedgerows this applies to, which is the length, location, and the importance of the hedgerows, which is a very vague term and could, if it weren't further particularised, actually could have been the source of quite a lot of dispute. So let's dealing with those in turn, dealing with length. So a hedgerow is protected if it is more than 20 metres long with gaps of 20 metres or less in length, or less than 20 metres long that meets another hedgerow that is longer than 20 metres at each end. So that's the length. Then we look at the location. So not all hedgerows are equal. Land used for agriculture or forestry, land used for breeding, keeping horses, ponies, or donkeys, common land or a village green, a site, a triple SI, or a SAC or SBA, a local or national reserve, and land belonging to the state. So you've got your length, you've got your location, and then we come to the really knotty one, importance. Now, it's probably worth going into the if this is an issue that you have to grapple with, and it's probably very important to go into the exact wording of Schedule 1 of the hedgerow regulations. So, but in outline, if it is being used to mark a parish boundary that existed before 1850, contains archaeological features, is completely or partly in or next to the archaeological site listed in the HER, marks the boundary or estate of a manor that goes all the way before 1600, or is part of the field systems that that relates to any building or other feature associated with the field system that existed before 1845. So you've got to go off to the County Records Office in such cases. Contains protected species, contains species that are endangered or vulnerable and rare and identified in the British Red Data Books, or includes woody species. And then woody species is then further defined within the regulation. So if you are grappling with hedgerows, this is only outline advice. Unfortunately, you would really need to go into the weeds, forgive the pun, of the regulations. So, if obviously it is unclear or whether your hedgerow is covered from the regulations, it's always best to speak to the local planning authority. But if your hedgerows is covered by the regulations, you can apply under Regulation 5 of the, sorry, that should say 1997 regulations, to remove a protected hedgerow. And so you apply, the LPA will either issue a hedgerow retention notice or give you written notice giving permission. And then you can go off and make appeals. If the LPA does nothing, normally they are then allowed to remove the hedgerow. But again, I would emphasise that you check the exact wording of the regulation, because it does get quite knotty. But there are certain exemptions, like with the tree protections, where you don't need to then apply for the LPA for separate permissions. There are 10 exceptions, but probably the most relevant for you are Regulation C for obtaining access to land where another means of access is not available, or if it is available, it's only at disproportionate cost. A little unclear about who decides about whether or not cost is disproportionate, whether or not it's the LPA or yourself, but I suspect, bearing in mind that it's operating as an exception, the LPA would then have to take out an injunction saying that it is disproportionate cost. Then probably the most relevant is exception E, for carrying out development for which planning permission has been granted or is deemed to have been granted. So if your planning permission covers the land and it obviously specifies that the hedgerow needs to be removed, then again, then you can obviously remove it. Now, but what's interesting here is if we have a look at the exact language, rather than the tree protections order where it says it's got to be necessary, this one doesn't use that language. It just says merely for carrying out development. So I suspect that means developers have a slightly wider area of judgment as to whether or not they can use this exception, because it's not as tightly defined as the tree protection one. Turning then onto my last topic, and I believe I'm at 15 minutes, so I think I'm broadly on time, is we are turning to the NPPF and trees. So, and now obviously, as I say, trees impact on amenity, trees impact on the environment, trees obviously have nesting birds in them. These are all things that you will be grappling with. But there are specific areas that you need to be aware of. So, for example, paragraph 136 specifically says new trees should be tree lined and trees should be retained wherever possible. So much like the positive duty under the Town and Country Planning Act, very weak duty, but a positive duty nevertheless, is that you should be thinking about trees. Paragraph 180B, decisions and policies should recognise the intrinsic character of the countryside, including trees and woodlands. Obviously, recognise is a very interesting word because it's obviously up for debate about what it actually means, and it inevitably comes down to planning judgment. Then we get paragraph 186, and this is probably the one with the most teeth to it, is development resulting in the loss or deterioration of irreplaceable habitats such as ancient woodlands and ancient or veteran trees should be refused unless there are wholly exceptional reasons and compensation for loss or deterioration. Ancient and veteran trees is defined in the glossary. So if we turn to the case of Juddon and Tower Hamlets, here the High Court held the local planning authority had misinterpreted what is now paragraph 186C, since they included the mitigation proposals in their assessment of wholly exceptional reasons. Now, this is quite a famous tree because Judi Dench tried to resist its removal, and despite the picture, it was in the middle of Tower Hamlets. What Owsley J said, that there was an error, that the NPPF requires a wholly exceptional reasons regardless of any proposed mitigation. And this is discussed at paragraphs 107 to 113. Now, the question of whether or not there are wholly exceptional reasons is a question of judgment, but the question of whether or not there are wholly exceptional reasons is to be taken before you turn to the question about whether or not there is proposed mitigation. They are to be kept separate, and you're not allowed to dilute the wholly exceptional reasons on the basis that mitigation is forthcoming. So that sort of concludes a sort of very brief run through of everything I wanted to cover. I would emphasize that these rules are quite technical. So should you be looking at a site that has an impact on trees, has impact on hedgerows, it's very important to get specific advice working through the regulations in exact detail. Thank you very much.
Thank you, Joe. Disclaimer. Not sure what the disclaimer's for, but just before I introduce Dan, for anyone interested in the interrelationship of the planning legislation with the Forestry Act, see Arnold White and the Forestry Commission in 2022, where the Court of Appeal gave me a bloody nose for suggesting that the planning regime ought to take precedence to the Forestry Commission, the Forestry Act regime, and the exemptions in Section 9. It means it requires very careful thought if you're seeking a felling license ahead of planning permission, and you need to work it out very carefully. Anyway, with that note of caution, and Still scratching my head slightly over the disclaimer. I'm now going to hand over to Dan Kolinsky, our final talk, who's going to give, no doubt, very welcome tips on how to win and indeed to lose a planning High Court case. Dan combines not only extensive High Court and inquiry planning experience with broader local government practice and significant Supreme Court advocacy experience, but he's also for his sins, a Deputy High Court judge in the Planning Court, and sits also as a recorder and is an accredited mediator. Dan, please continue.
Thanks very much, David, and good morning to everyone. I think the disclaimer is part of my slides. It's
I wondered about that.
Yeah, no, it's actually. I think I'm going to disclaim my ability to move the slides electronically because it doesn't seem to yet be working. But the reason that I start with my disclaimer is this talk was not a topic I signed up for. I was allocated it, and it's one I approach with a degree of trepidation. I have occasionally won a case in the High Court. I've certainly had occasion to lose them. And as David has indicated, I'm at the very early stages of a sitting career. And so it is that experience in particular, I think, has led me to reflect on what works, what doesn't work, and to have very much a sort of dynamic perspective on putting High Court challenges together and defending them.
If you don't mind me interrupting, Dan, you did actually win rather spectacularly one of my cases a year or so back on NHS contributions in housing cases. So I don't think you should sell yourself short.
No, well, thank you. But this is a few reflections on that experience in a sort of fairly random order. But I hope it's of some use in any event, and I hope I can move the slides because I'm not quite managing it yet. So. Can we move on to the next slide if what I'm doing isn't working? Thank you so much. Okay, so my starting point is the importance of focus, and this is sort of from the claimant's perspective in particular, but it's absolutely critical to analyse the precise decision that you're attacking, what the exact basis of the attack is going to be, the nature of the decision. Is it the right decision? Have you got the first in the relevant chain of decisions that you are directing your challenge at? I think it's absolutely imperative to undertake a really careful legal evaluation of the basis of your challenge. And the more I do this job and the more that I and sort of my limited experience, I think it's critical to actually filter the possible challenges into a limited number of best points. Obviously, there are different views on that, and no two cases are the same. But as a generality, I personally would suggest that sort of no more than about 4 points at most would be a sensible way to go. The reason I think for that is you are crystallizing. I think if you've got a whole host, I mean, there are cases where you see 10 grounds, but I think the likelihood of that is that your grounds 8 to 10 are going to distract from what might be your best point, which might be ground 1 or ground 2, and take away the judge's attention perhaps of giving effect to what your best points are. So I do think less is more, and I think that's really critical in formulating challenges from a claimant. And when you see good challenges where they're taking maybe 1 or at most 2 points, it's actually an expression of confidence in their challenge, and I think it can be particularly effective. In terms of framing the challenge, I think it's absolutely critical to find the best way to tell the story. That might be through witness evidence, it might be through a narrative. Again, there's no kind of one-size-fits-all rule, but you absolutely want to frame the legal points against the strongest possible narrative and tell the story about what's wrong with the decision-making, how it impacts on you, how it should have been undertaken, And it really is an exercise, I think, effective advocacy in telling that story, which starts from the way in which the claim is framed. Kind of recurring plea of identifying the critical documents and being really clear about streamlining what those are, so that you are limiting yourself to what the critical documents are, obviously fairly representing the nature of the decision and where it's possible to do that, to drill down to fair extracts of what you've got, so that actually there is a kind of direction and focus to what you're putting forward, and always keep in mind what you're asking the court to do and why you're asking them to do that. And can I move? Thank you so much. And I think in terms of how one frames the challenge, it is worth thinking about how the law develops. And there's kind of often two options about how you put forward your legal points. Are you trying to establish some fundamentally new principle? There are cases that do that. I mean, one might say the Finch case in the Supreme Court is an example where a new principle has been established, and if it's a new statutory provision, then it might be the first decision on this. But usually, and more typically, the law sort of moves in incremental steps. And I think obviously being able to present a favourable outcome actually as a application of what's already been decided, or as a very minor and logical extension of principles that have already been embedded in previous cases, is often the most effective way of packaging your claim. My purpose in this slide is to emphasize the importance of thinking about that, and also to draw attention to what I think is a really thoughtful and interesting speech which Mr. Justice Fordham gave at the Public Law Project conference in October, and it's available on the HMCTS website. And although it's not a planning speech, it's a general administrative law speech, I think it's really interesting as a resource for people practicing in judicial review. And one of the things that he lays out in his own sort of inimitable and practical way is this concept of the law moving incrementally and in sort of staggered and slightly unpredictable steps. And so I would thoroughly recommend that as a thought piece around how one frames one's legal arguments. And my personal experience would suggest that most cases are probably best framed in a sort of incremental step rather than a step change way. And I'm going to try to move to the next slide. Maybe I've done it. Thank you. So the again, sort of from a sort of early sort of judicial perspective, I think actually, is the material put forward in a way that actually helps the court? And it's really interesting to see that, because if you've got a case that comes to you, certainly at the permission stage, and you're facing a bundle that is 600 to 1,000 pages long, it's really, really difficult to find your way through it to what's actually important in a realistic amount of time that's available to you, given the other commitments that are being presented to you. And so the skill of actually converting the filing cabinet into the relatively thin bundle for a permission hearing, or perhaps for a substantive hearing as a core bundle of what really matters, is massively important, and it really helps to give the kind of clarity of focus of your challenge. So I think it's really important that is something that is, again, at the forefront from a claimant's perspective of making sure the materials are really well organized in a way that is helping the court. And that doesn't mean the whole emphasis on focus. It doesn't mean that you frame a case that is superficial. In fact, quite the opposite. You need to dive in, and the court will want to dive in to the detail that really matters. But the critical task is to actually take the court in the most efficient and measured and directed way to the detail. So it may be that actually precisely what's said in one of a number of wide-ranging supporting documents to a planning application is absolutely critical to framing the case, identifying a mistake, or if we're thinking for the defendant in answering it. But you don't produce the whole plethora of material that's put forward. You take the court to the detail of that in a fair, realistic and targeted way. And so I think the metaphor of a deep dive is useful because it's the counterpart to the focus, and probably advocacy and preparation is kind of actually, you are a diving instructor, you're directing the court into the material that matters. You've got much more knowledge of the range of material that there is, and then you're actually showing them where the hidden gems are, which is going to actually be what the case turns on. And so I then just draw attention to the fact that certainly in the administrative court guide is very much seen by the judges as a very useful reference point, and I think many practitioners also are referring to it more and more. For present purposes, there's a couple of provisions that I think are specifically important. The rules on when and whether to serve replies have recently changed. There used to be a sort of presumption against it and an indication that there wasn't a rule and you needed to make an application to put in a reply. That changed, I think, from April of this year, and there is now provision in the rules and the guidance for the service of a reply. But not in every case, but only where it's necessary to assist the court in determining permission. And the example given in the guide is where an acknowledgement service raised a discrete point that has not been addressed in the claim form, and it's always supposed to be concise. I think it's no more than 5 pages, and not repeating matters that are in the claim form. So I think it's critical to good advocacy that you've got those constraints in mind in replying to the summary grounds. The other document I draw attention to, which I think people need to be aware of, is the expectation in the guide that actually for a substantive JR you produce an agreed list of issues, an agreed chronology, an agreed list of essential documents for pre-reading. Now, in big cases, I have done that, and it's proved to be very, very helpful. Usually, it's not an ordeal to get to that stage. Sometimes it throws up points and you need to actually spend a bit of time on it. Certainly in big cases and in front of certain judges that have recently gone up to the Court of Appeal, this is seen as absolutely critical. But to be honest, I've rarely experienced it in the cases that I've been a judge on. I don't think anyone's ever produced them. And I've had more than one experience where I've actually been involved in putting these together, and the court hasn't received them, and the court hasn't even been aware of missing them, and then the court hasn't been terribly familiar with when they've been provided. Oh, I've never really seen these before. So I don't think they're universally used, but I think for my part, I think in the right case, certainly in a big case, that they can be a really helpful way of marshalling the arguments and helping the court. There we go. So then just a few words from the sort of defendant's perspective. I mean, it's very much the converse of what I said from the claimant's perspective. It's your job is really to explain the basis of the decision legally and factually, explain what the role of the court is. You have to rein back the court from what might otherwise be its instincts, because case law or the nature of the duty means that actually there's a high level of deference to the administrative decision maker. You need to actually engage with what the claimant's analytical argument is and respond. Is their legal framework wrong? Have they got the right framework, but they've applied it in a way that's just missing out crucial facts or mischaracterizing what's actually happened in the decision? And you need to be clear about what you're asking the court to do and why. Now, the illustration on the right there is the old chestnuts, and I think it's unpersuasive for a defendant to simply trot out kind of the case law planning merits are always a matter for the decision maker, etc., etc. If you're doing that in a kind of generic way rather than a way that's actually a meaningful response to the articulated claim that's specific in its the basis of replying. I think there's a strategic decision to make about whether you put in evidence. When you put in evidence, it may be necessary at the permission stage. You might need to think quite carefully, although that's an early stage. Is there something missing from what you can put into a summary grounds of defence, which you need to put in order that the judge will have everything that they need to refuse permission? So I think that is a decision that's quite important from a strategic point of view for a defendant. And I would also say that if you're trying to rely on Section 31, that relief should be refused because the decision would have been substantially the same but for the matters complained of, then that might need evidence and that might need to be front loaded into the summary grounds stage. From an interested party, I think the big thing is just get out of the way. Don't get yourself out of the way. Do not put yourself in the way of what the defendant wants to say. Do not tread on their toes. Ask yourself, what do I need to add? And I think the answer might well be nothing. You can coordinate by the scenes. There might be things that you can put certain background documents that are important that you've got a perspective on. There might be one or two bits of evidence that you're better placed to give, but what you do should complement what the defendant is doing. And if there's any risk of telling a different story, you must avoid that, because actually that really strengthens the claimant's case if the defendant and the interested party are explaining what's happened in a conflicting way. I think it's really important, my personal view, to get the tone right. And I think it's absolutely critical that one strips out the kind of overplaying of one's hand, strips out the adverbs, the superlatives, and actually just puts the material in a dispassionate, objective, evidence-based way. So for me, expressions like misconceived, an unrealistic submission that the case is totally without merit, that tends to distract from the quality of the material. And I'm just gonna, I think I've got time to do this, but just give you an illustration, I think, of what I think the tone of public law proceedings should be from the judgment of Mr. Justice Chamberlain in a decision called the Crown and CPRE Somerset against South Somerset Council, and it's a case about apparent bias, and he found that there was apparent bias, and it had two councillors had participated in a decision that they shouldn't have participated in, and he analysed it all quite carefully, made his decision, and then he ended with this paragraph, which I think is wonderful. He says, "This outcome does not reflect adversely on the integrity or professionalism of either councillor. Both councillors declared their interests openly. Neither attempted to hide their associations. Both followed the advice of the monitoring officer. That advice flowed from her honest analysis and the application of the code. The monitoring officer went wrong in law, as many public decision makers and most judges do at some point, but was not otherwise at fault." And I think that's a really useful indication that actually, there are legal disputes. The law is very, very complicated. It's not about people doing things personally wrong. It's just about actually that we're functioning by correcting things as we need to, not personalizing the attacks, taking the heat out of the situation and just being objective. And I think that's Mr. Justice Chamberlain there, in his own quiet way, just beautifully sets that tone. Couple of final points. Redactions are a hot topic. There's recent guidance in the practice guide about when and in what circumstances one can redact. the widespread tendency to take things out on a very broad view of GDPR is frowned upon by the court. All redactions need to be justified by evidence. They should not interfere with the ability to understand the decision, and there's guidance of that in the practice guide, which I've referenced there. Also, be aware that the court sees the duty of disclosure as now being much more a duty of explanation. So if you are throwing information at the claimant as a defendant or an interested party in a way that obscures what's actually happened rather than illuminates it, that might be not sufficient fulfillment of your duty of candour. And then the golden rule, I think, whichever side you're on, must be to help the court. Now, the image on the left rather, reflects perhaps how the case comes to you. It might reflect how the judge is feeling based on not necessarily your case, but all of the other demands that they're faced with. And really the secret of it all is to signpost the clearest, the simplest, the most compelling route to the favourable outcome that the judge can actually trust and see as a sort of secure and easy way of deciding the difficult case where actually each side is putting forward a compelling argument. And so building the confidence through the way the case is thought through, the way the case is presented, taking the heat out of it, seems to me to be the sort of the critical skill that this is all really about. And so finally, to do that, hoping it goes, yeah, it goes next slide. That's where you'll do it in the High Court, but it's also where the Court of Appeal lives, and you need to be clear in the way that you frame your case so that the judge isn't persuaded by your submission, but you end up in the worst of all worlds where you've won badly because you've not really thought through the analysis, and you end up getting dragged off to the Court of Appeal and it all being overturned. So the judge will, part of the judge's thinking will be, is this something that actually will survive the scrutiny of the Court of Appeal? And that needs to be also at the forefront of your minds as you frame the case. So I think that's exhausted my time slot. Thanks very much. And I'll hand back to David for questions.
And thank you. Exactly 20 minutes. Excellent timing. And if I may say so, very wise words about litigation, about which we can talk a little more in a moment. Could everyone turn their videos on, please? I don't know whether Hilary, you could turn off the slides and just put the video on, because I can't see anything at the moment. I don't know whether anybody else can. Ben, I thought we might start just by considering one of the issues that's been which has arisen in the questions and answers, which is the seek to further duty in the case of AONB National Landscapes, and how that ties in with the various other duties, bearing in mind that natural beauty is widely defined to include ecological and geological issues, and how that ties in with the other initiatives under LURA and the Environment Act in relation, for example, to local nature reserves and nature recovery. I know I've spoken about this in the past, and it did strike me at one stage that there wasn't very much joined up thinking, but matters may have moved on. So your view?
Well, I don't think it ties directly in with those things, but clearly there's an obvious linkage. There are different types of duties. So, for example, the duty in, I think it's section 40 of the NERC Act relating to biodiversity is an example of a change that was made by the Environment Bill, potentially with the view to strengthening that duty, but it doesn't include the same wording, same language. I think the focus of the section 85 duty is likely to be on AONB management plans, and that would probably be the sort of touchstone for where you would go to ascertain whether you're furthering those purposes, and they may well incorporate elements of those other regimes as well. But from what I've seen so far, that's likely to be the focus of a local authority's consideration of that, and other authorities' consideration of that duties.
But I think there's scope for confusion, certainly in
Very much
future.
so.
Well, no doubt we'll find out.
Yeah.
Can I ask in relation to trees, perhaps, the question about, well, what do I do if I'm proposing a new road and there's a tree in the middle of it, as in your picture, Joe? What's the right approach to take?
Well, I mean, as with all of these things, the first thing to do is get a baseline understanding of whether or not the local planning authority agrees with you that that tree has to go. Following on the Wellingborough Walks case, if there is a landscaping condition or a tree, an arboricultural assessment condition, I would discharge that first before going anywhere near a tree, because that keyword necessary, to borrow other sort of mindset, is a sort of precautionary approach. And so unless everyone agrees it's necessary, I wouldn't touch the tree.
Yeah.
And then obviously also check whether or not it's nesting season, because there might be other conditions attached as well.
Yeah, I mean, I suppose it's a bit like the sequential test in flood risk. You've got to have done the sequential test before you can apply the exceptions test. You can't go directly from, oh well, it's low flood risk, to mitigation. You've actually got to do your sequential appraisal and then move on to the second stage. So it's a bit like that, isn't it?
Yes, I agree.
Yeah. Ed, I gather that Mead maybe or is going to the Court of Appeal on the relationship of PPG and national policy.
Yes, that is correct. I think given the time, though, probably won't get a judgment until some point next year. So,
do you know who's hearing it? It won't be Lord Justice Holgate, I'm pretty sure.
I'm pretty sure it won't be him. But no, I'm sorry, I don't know specifically who it is. Perhaps someone on the call has some insider info. I don't know.
Yeah, I should think probably Lord Justice. Sir Keith Lindblom, the senior president, may well be on that. I know there are a number of people have had to face both Sir Keith and Lord Justice Holgate in the single case, which they will be able to avoid in Mead at least, in terms of questions being fired at them from all angles. Okay, thanks. In terms of practice of planning cases and JRs, Dan, I mean, like you, I sit as a deputy. What do you think the wisdom is, as you get in some cases, of piling in vast amounts of documentation into the application for permission?
I think it makes life very, very difficult. I think my own view is it's worth being selective and focused. Certainly as the claimant, I think it's impossible to navigate around huge amounts of material. Yes. And as a defendant or interested party, you might be able to add one or two bits to it if necessary. But I think you need to keep in mind that the judge is likely to be under huge amounts of pressure dealing with it at the commission stage.
Well, I don't know about you, but I there is a certain sinking feeling when paper applications are brought in when you're sitting, and the 6 lever arch files which you've got to go through. And it doesn't necessarily follow, does it, that just because you've overloaded the judge is necessarily going to be predisposed to granting permission because it looks complicated?
No, I think actually potentially the reverse. If you haven't got a sort of clear a kind of well thought through case, it can actually very much detract from the merits if it looks like it's a filing cabinet without focus.
Yeah, particularly if you get a clear set of summary grounds from defendant and or interested party, which steers you through in a very clear way as to decision making.
Yeah, absolutely, and that's the skill for those summary grounds. Really, is that if they can help the judge to make the decision that they want to make and give the judge confidence that that's the right decision, then they're invaluable.
I think the creation of judicial confidence in what is being said and what is being presented is very important. Tim, I don't know whether you've got any perspective on this.
Well, I mean, I would say, I mean, the absolutely critical insight for advocacy, I don't sit in the High Court, but I sit elsewhere, but also as an advocate, is, judges are human. Make the judge your friend. If you make the judge's life hard, it's a very human reaction for them not to be on your side. And of course, they won't be overwhelmingly, they won't be overwhelmingly dictated to by that, but in practice, it makes a difference. Make it simple, make it straightforward, but take your best point and so forth, as far as Dad pointed out.
What do you both think about redactions and the duty of candour?
Well, we've got this. Do you mean the IAB decision? There's the IAB decision recently on civil servants' names, which is saying that you can't routinely redact civil servants' names. That's probably going to be less relevant to planning cases.
Yeah.
But I suspect it does support the general idea that routine redactions without a good reason, obviously LPPSI is different, shouldn't be allowed. The working assumption should be that it's, even if it's only contextually, it's going to be relevant to not redact what look like not terribly important details, and therefore you may not want to, you shouldn't be redacting.
Yeah, I mean, Dan.
So because I think it is that decision, but I think that decision has basically been put front and center in the administrative court practical guide. So those examples of there was this sort of routine policy of protecting the identity of civil servants, and it's seen as, well, no, that's going to obscure the decision-making process. So I think there might still be the ability to protect very junior individual civil servants where doing that is not going to distract the court from understanding the true basis of the decision. But there should be really a presumption against that, and everything needs to be carefully justified.
Yeah. I mean, I can give you an extreme example of a case I heard, which was a challenge to a decision by the London Borough of Brent about whether the duty to house two young Syrian refugees who were of school age, and they'd been through the mill a bit, but the Home Office had accepted them under the scheme that applied, and Brent were being very resistant. And I got a heavily redacted series of housing minutes and reports for about the last 4 months of the decision making, and there was no justification for the redactions other than the fact that when I ordered the production of the unredacted copies, it was quite clear that they'd acted unlawfully. And it all turned out to be very embarrassing, and it shows quite the reverse of what you're both suggesting, which is the need to keep redactions to an absolute minimum and to be able to justify them on compelling grounds, and not if they're going to conceal key information from the court. Certainly not in the absence of a very clear explanation in witness statements.
Yeah, I mean, the only basis in which you can redact, unless you've got public interest and unity, which is not going to be the world we're dealing with here, is that they're irrelevant, and you just shouldn't assume that they are, because other people will see irrelevance that you may not be aware of.
Well, that's the risk, and the court's always going to lean in favour of wanting to see the complete document. Yeah. Well, I think we've reached 12:30. Can I firstly thank everyone for attending? We hope you found it interesting and informative. And secondly, can I thank all the speakers for their interesting talks and the discussion. So thank you all very much, and goodbye.